My lord, I have filed this petition on 29/10/2025, my lord. This matter may be listed for motion on 14th, my lord, on Friday.
Friday, not possible.
My lord, because connected case is listed on Friday, my lord.
On Wednesday, 19th. Friday.
Yeah.
Oh, so your reading is completed. Since August, it was not listed. There is an urgency. Can it be on 19 months
Which matter?
for admission month?
Which matter?
Well, this matter is pending month.
Okay.
21? 21. Item number 14, can it be taken up tomorrow or day after any day? Tomorrow is
Item number 14.
14, tomorrow. The part had met. Hearing matter.
Tomorrow,
Day after.
day after.
Day after.
Okay. On the
Alright.
fair being made by Mr. R. Goswami. Learned counsel for the appellant.
The consent to the other side.
You- Okay, Lord consent from the other side, as for testing the matter. Day after tomorrow, fair alone.
Lordship, in item one, we have filed an affidavit in opposition yesterday, Lordship. In item one, let
It
it
is not placed on record.
not present record, Lordship.
Okay.
So we'll be allowed to call for law.
May I please, Lordship? So praying for listing of a case for motion on tomorrow, Lordship. Otherwise, Lordship case will be infectious, Lordship. Government is going to distribute, Lordship, appointment letter on day after tomorrow, Lordship. So some urgency is there, Lordship, may be on tomorrow, Lordship. If government also issued a notification, Lordship, they are going to appoint on 13th, Lordship. We have brought them tomorrow, Lordship.
Okay.
Highly obliged.
In respect of item number 8, I have a prayer for adjournment on behalf of Senior Counsel M.K. Chaudhary Mayor. He is in bereavement due to demise of family members. I had taken the consent of the other side, Mayor. Can it be taken up on 25th of November, the hearing day, Mayor? We have some urgency, Mayor.
Sir, Chakravarti,
P. Chakraborty, Mayor.
learned counsel for the petitioner with consent from the other side, as for testing the matter.
On 25th of November.
Hearing this.
I'm deeply obliged.
I beg to mention a matter for listing for withdrawal, Lordship.
When?
Tomorrow, Lordship.
That's for withdrawal.
For withdrawal. Deeply.
Well, with the concern of the other side, I beg to mention item 15, my lord. We have some personal difficulty, my lord. Kindly let this matter be come up after 1 or 2 weeks. Already adjournment slip moved, my lord.
Mr. S. Das, learned counsel for the, learned counsel for the state
Higher education.
higher education department with consent from the other side, as for testing the matter.
After 2 weeks or 1 week.
After. Here. Yes,
May I please, your lordship? I beg to mention for listing, lordship, in a admission column.
when?
Next week, Monday, lordship.
Monday, not
possible.
On Friday,
Next week,
21st November.
highly obliged.
Lord, I beg to mention for listing of this case in admission column, my lord. Matter is regarding in charge headmaster, my lord. It will be infectious if not listed. So next week or any after 10,
On 26th November.
26. No?
May I please, your lordship? I beg to mention for listing, lordship, in admission column. Any date, lordship.
28th November.
May I please, Lordship, for listing admission matter, my lord, relating to compensation upon, my lord, on Thursday, my lord, kindly.
This Thursday,
This Thursday, my lord.
motion matter,
My lord?
motion matter.
No, admission, my lord. But kindly, this matter is very urgent. The department has taken the documents from me, my lord, and thereafter they have asked
19th,
for.
on 19th, Wednesday. We have cases, Lord. Friday, Monday, on Wednesday, 19th November.
Obliged, my lord.
May I please, your Lordship, I beg to mention a WBC for admission,
When?
which was last listed on
When
3/9,
do we want?
next week.
Next week?
On 24th November.
Yes.
Yes, item number 15, my lord, respondent, official respondent, they have mentioned it, my lord. I'm about the private respondent, my lord. Only this date may be fixed, my lord.
After 2 weeks,
Any day after 2 weeks.
hearing matter.
Hearing matter, any hearing.
27th, 27 November.
20, can it be 28 or 20?
27 is Thursday, hearing matter.
27.
Then on December.
My lord, with respect to
Second
item,
December.
27.
27 is Thursday.
Ah,
27 November.
November.
My lord, with respect to item number 9, the department was asked to bring the SLC report, my lord, the resolution taken by the SLC. My lord, that could not be traced out, my lord. I need some time, at least 1 week time, my lord. I have spoken to the other side also, my lord.
Item number 9.
9, my lord. My lord has already heard this matter.
For the pair being made by Mr. S. Plus.
Yes, my lord.
Standing counsel for the
Higher education.
higher education department. With consent from the other side. The matter is adjourned to be listed on 24.
21st? 21st.
Let's say regarding item number 16, I
Absolutely.
would like to adjourn the matter for 2 weeks. Okay. We have already taken the consent of other parties.
16, right? We are from the petitioner, we have no opted.
Mr. Arsi Alam. Guardian Council appearing on behalf of Mr. P.J. Verma, Guardian Council, Wadi, with consent from the other side, president in the matter. After 2 weeks, Lord. Why 2 weeks? Some emergency is there. Some other emergency work is there. After 1 week.
2020. 20 November.
Made please, Your Lordship. Lordship, I beg to mention for listing on contempt matter, my lord. May I pray next date, any day, next week, any day?
24 November. 24 November.
It's little earlier.
Yes, বহুত আছে 2010
I am deep.
20 November.
We could consider also 18 lot. 18. Maybe taken about 27 November lot.
When?
27 November. 27 November.
27th of
November.
Of the pair being made by Mr.
SM Borwa. So number 8.
S.N. Porwa. S.N. Porwa, allotted council for the response number 8. With consent from the other side?
Yes,
Any
for the
objection?
The only thing is that date may be fixed.
Let's for this thing, the matter. On
27 Thursday.
all right.
pair.
Items for admission, Pathak matters, item 2 to 6.
Yes.
My lord. My lord, the petitioners before this honorable court, my lord, item number 2 to item number 6, my lord. They've been serving in various venture schools recognized by the state of Assam prior to 1991 in various districts in the state of Assam, my lord. In the year 1993, notification dated 5/10/1993 came to be issued, my lord, which is at page 25. If your lordship has come to page 25, my lord.
Yes.
Yes. In exercise of the power under rules 5 and 7 of the Assam Elementary Education Rules 1977, the governor of Assam is pleased to notify the following rules and guidelines and policy decision for provincialization of the venture LP, ME, MEM, Junior Basic, Senior Basic, MV schools in the state of Assam, which will come into force with immediate effect. This was the policy, my lord. Thereafter, 1, 2, 3, 4, 5, 6, and 7 were various guidelines and parameters based on which the schools were ought to be provincialized. Thereafter, my lord, certain schools under this policy were provincialized and certain schools, my lord, were left out. Certain schools were provincialized and certain schools, my lord, which fulfilled the criteria and parameters laid down in this policy were left out. Pursuant to that, in the year 1999, which is at Annexure 2, there was a settlement which was reached, my lord, between the members of Assam Shikhok Karmachari Samanvay Committee and the government of Assam. Page 27 and page 28 are typed copies. But my lord will kindly come to page 30. Page 30, my lord, item number 3.
Yes.
Yes. Provincialization of schools and increase of ad hoc grant. As decided at the meeting dated 13/3/1999, the government agreed to provincialize the high schools and high madrasas recognized in 1992 and 1993. And in the case of middle schools, our case is under middle schools, my lord, recognized in the year 1990, 1991, and 1992, and 10 LP schools on seniority basis in each constituency with effect from 1/3/2000. This was one of the agendas, my lord, on the items on which the settlement was executed between the parties, my lord, the state of Assam being one of them. Pursuant to that settlement, my lord, nothing happened. Nothing happened. The government did not take steps for provincialization of the petitioner schools, along with similarly other schools which were left out. Now, my lord will kindly come to page 35. Page 35, Annexure 5. This was before the Honorable Court, my lord. This was pursuant to an order dated 17/2/2004. Heard, so and so. Your lordship is at page 36. The order starts at page 35, my lord. The operative portion is at page 36 onwards.
Yes.
Yes, madam. Heard so and so, the learned counsel for the writ petitioners, and Mr. So and so, learned counsel, standing counsel for the Education Department, Assam. This petition has been filed by the General Secretary of All Assam ME/MEM School Teachers Association. The prayer incorporated in the writ petition is for a direction for provincialization of the left out schools of the petitioner association situated in 8 districts in the state of Assam. The grievance is that the school in question fulfilled the requirements for the purpose of provincialization, and despite that, the respondent authority have not taken any decision in this behalf. This court, in exercise of its powers under Article 226 of the Constitution, is not inclined to issue a mandamus to the respondent state for provincialization of the school. Whether the petitioner schools fulfill the eligibility criteria is a matter which has to be inquired into by the respondent state. In view of the above, this petition is disposed of, and the respondent authority, particularly the Secretary of the Government of Assam in the Education Department, is directed to examine the matter and pass appropriate orders as may be considered expedient in the given situation for provincialization of the schools in question. The petitioners shall submit a representation to the Secretary of the Government of Assam, so and so, my lord. This was the direction which was passed. Pursuant to that, my lord, the order of this honorable court, there was a communication from the government to the Director of Elementary Education at page 38. Page 38, my lord. Your lordship has come to page 30, my lord. Sir, in enclosing herewith a copy of the representation received from Sri Nagendra Chandra Burman. He is one of the petitioners, my lord, in a subsequent writ petition listed today, my lord. All Assam ME/MEM School Teachers Association, along with so and so, I'm directed to request you to furnish a detailed report along with the following information to this department by 31/3/2004 without fail for further necessary action from this end. First, reasons for non-submission of proposal of provincialization of 127 schools along with 255 schools proposed for provincialization during 1990. Whether 127 schools fulfill the terms and conditions for provincialization as per the existing rules, guidelines, and procedures in force, and how many schools are there in the same line. A detailed report indicating your wise reorganization. And three, a detailed particulars regarding financial involvement towards provincialization of 127 ME, MEM schools and also for the remaining schools as mentioned in 2 above. My lord, there has been no response to this communication as of now, my lord. Pursuant to this, the Honorable Court on the earlier occasion had directed the state to file an affidavit on this annexure. The response of the state is that the file is untraceable, my lord. Thereafter, my lord, at page 39, page 39, my lord, we were constrained to approach this Honorable Court once again in the year 2011. WPC, my lord,
It was withdrawn.
it was withdrawn. The reason being, my lord, the matter was withdrawn in the year 2012 with an assurance of provincialization of the petitioners. That assurance, my lord, came to be fulfilled at page 43. Page 43, my lord, has the provincialization orders pursuant to the case, my lord, of 7 districts in the state of Assam. Page 43.
Hmm.
Now, my lord, your lordship will kindly come to page 44, serial number 11.
Hmm.
Page 44, serial number 11. Your lordship sees Honaton Hevastrom Girls MES. My lord,
Hmm.
the district is Bozali district, and your lordship sees a date 1/1/91 on the right hand side, my lord, just besides the name of the school.
Hmm.
This date is the date of permission and recognition.
Yes.
Yes. Page 44, my lord, Honaton Hevastrom Girls MES is the petitioner in item number 6 today, my lord. Item number 6. Then, my lord, will kindly come item number 6.
So this item number 6, here the petitioner is on Robin Medhi.
No, my lord. Yes, my lord, your lordship will see the fourth column, my lord. Robin Medhi. Not there, my lord. At page, the writ petition, page 44. Initially, the petitions were filed in the name of the schools. The fourth column, my lord, your lordship will see assistant AM, my lord, 1 Robin Medhi. Your lordship sees that.
Page number 44.
44, my lord. First column is 11, second column is Bozali, third column is Honaton Hevastrom Girls MES. The fourth column is 1/1/91. The fifth column, my lord. Your lordship sees Robin Medhi.
Yes.
Yes, my lord. Then the petitioners in item number 6. Then, my lord, will kindly come to page 46, serial number 27. Your lordship is at page 46.
Hmm.
My lord, 46, serial number 27, Borpeta, Pohumara Ansolik MEM school, my lord. This is item number 2 that you are arguing on, my lord. The date of recognition is 1989 and 1990. Now, my lord will kindly come to page 56. 56. Page 56, my lord, serial number 4. This is for Buxa district.
Hmm.
Serial number 4, Musolpur, Baksa block. The school's name is Athiabari Girls ME School. That is item number 4, my lord. Hiten Padgiri. Item number 4. Your lordship sees that. The date of recognition is 1985, my lord, prior to 1991. Now, my lord will kindly come to page 71. 71, my lord. 71. Serial number 35. It is Bilasipara. The school's name is Bamuni Sotogirari. It is item number 5, my lord. Nogendra Chandra Bormon, my lord. Nogendra Chandra Bormon. Permission and recognition in the year 89 and 1991. So, my lord, pursuant to the orders of this honorable court, my lord, the petitioners were provincialized. But rather from the year 1993 with effect from 1991, they were provincialized from the year 2013. Being aggrieved by losing out on the 14 years, my lord, in the intergenum, my lord, the petitioners had preferred another writ petition before this honorable court. The order, my lord, is at page 79. Page 79. Page 79. Page 82, my lord, is where the facts of the case have been narrated, my lord. If the first paragraph may be relevant, my lord. The petitioner's case, in brief, is that the state respondents carried out an exercise for provincializing 1,255 ME schools in the year 1991. The ME schools, where the petitioners had been serving since 1985, were recognized between 1990 and 1991, which has just been indicated, my lord, and fulfilled and the laid down criteria for provincialization, but were left out along with 235 other schools for no justifiable reason. A memorandum of settlement was thereafter signed between the state government and the representatives of the All Assam Shikhok Kormosari Homonoy Committee on 10/5/1999 for provincialization of schools and other related issues. However, nothing came out of it, necessitating the filing of WPC 1012 of 2004 for provincialization of the schools left out, dropped by the state respondents. And by an order dated 17/2/2004, this honorable court directed the Secretary, Education Department, to examine the issue and to pass appropriate orders for provincialization of the schools in question. Failure in this regard compelled the petitioners to approach this honorable court by way of a writ petition being WPC number 2432 of 2011. Based on the assurances made by the state respondents that the claim for provincialization be favorably considered, WPC 2432 of 2011 was withdrawn by the order dated 3/2/2012 before adjudication on merit. Finally, the services of the petitioners were provincialized by orders passed by the Director of Elementary Education on various dates in 2013. Since then, 2 of the petitioners have already superannuated from service in 2015 and 16, and the remaining 4 petitioners are due to retire very soon. The petitioners are aggrieved by the treatment meted out by the state respondents ever since 1991, when the exercise of provincialization was carried out, covering 1,255 ME schools, but living of the schools where the petitioners were serving, although these schools were purportedly similarly positioned. The petitioners' counsel submits that the petitioners were made to suffer continuously since 1991 till 2013, when the orders of provincialization was finally passed, and that too after multiple rounds of litigation. They therefore seek provincialization of their services with effect from 1991, when the exercise of provincialization was first carried out in 1991, and also grant of pensionary benefits thereafter, my lord. Accordingly, Mr. M.K. Chaudhary submits that the present petition may be disposed of, allowing the petitioners to submit a fresh representation, which should be decided by a speaking order by respondent number 4 within a specified time period. This was the order, my lord, which was passed in the earlier round of litigation. Pursuant to that, my lord, the representation at page 84 was preferred by the writ petitioners, my lord, before the Director of Elementary Education. Pursuant to which the order which is impugned, my lord, in this writ petition was passed at page 87. The finding of the government is that as per the Assam Venture Educational Institutions Act 2011, as amended in 2012, the proposal for provincialization of services of teaching and non-teaching staff of recognized upper primary school, including the petitioner schools, were submitted by the DEEO concerned along with the recommendation of the concerned DLSC to this office, and this office sent the same to the government for sanction of posts. Accordingly, the government has sanctioned post and this office issued the provincialization order. In the Assam Venture Educational Institutions Act 2011 as amended in 2012, there was no provision for giving consequential service benefit, including pensionary benefits from the year 1991, that is, from the date of recognition of the school concerned. In view of the above, the claim of the petitioners for given consequential service benefit, including pensionary benefit, etc., from the year 1991 cannot be considered as per the aforesaid act, hence rejected. Then, my lord, when this petition was pending, the order, my lord, the order dated 1/3/2023 was passed by this honorable court.
Page number?
My lord, this will be in the part of the order sheet, my lord, and a part of the annexure in the writ petition number 3, item number 3. If your lordship takes up item number 3, page 77, my lord. Page 77 starts at page 75. The operative portion starts at page 77. This order was, your lordship has gotten it, my lord. Heard Mr. M. Sharma, learned counsel for the petitioners, heard so and so. Thereafter, page 78. Petitioners are representing different ME/upper primary schools of different districts of the state claiming benefit for their past services prior to the date of their provincialization under the provisions of the Assam Venture Education Institution Act 2011 during its force. Since the schools in which the petitioners are serving are different and the period of their past services in their respective schools are also different. Moreover, they are from different districts of the state. Considering the same, the court is of the view that in one writ petition in the guise of common prayers of the petitioners cannot be considered. As such, each of the petitioner has to file their respective petitions for their individual and different prayers. In the case at hand, it is seen that the affidavit of the writ petition has been filed by one Hassan Ali, headmaster of petition number 2 school, namely Pohumara Ansolik ME School, Pohumara, District Borpeta. In view of the above, this writ petition has been considered with regard to the case of Pohumara Ansolik ME School. With regard to the 5 other ME schools, the petitioner shall file separate appropriate petitions if advised. So pursuant to this, my lord, this matter was initially titled as Thanaton Hevasram, my lord. It became Pohumara Ansolik ME School, and item number 3, 4, 5, and 6 eventually came to be filed. The facts of the case, my lord, are very similar. The claim of the petitioners, my lord, the claim of the petitioners was that similarly situated schools in the year 1993 under the policy 1993 were provincialized with effect from 1991. The state had not taken an action against the schools of the petitioners, which include 235 ME schools spread out across various districts in the state of Assam. Pursuant to an order of this honorable court in the year 2004, there was a communication as to the non-submission of report for proposal of the provincialization of those schools, which has been, as of now, my lord, as of today, been left unanswered. The petitioners having been eventually provincialized under the 2011 Act, the state has now taken the ground without answering the questions raised in Annexure 6 of the writ petition, that the petitioners cannot be granted consequential and retrospective benefits which flow under the 2011 Act. The prayer of the writ petitioners here is that the right of the writ petitioners had started not under the 2011 Act, but under the policy dated 5/10/1993, and the policy was meant to include all schools which were recognized by the state of Assam at that point in time, venture schools, and the schools of the petitioners were arbitrarily left out of the equation. And my prayer is that I need to be provincialized from the year 1991 under the rule, under the policy of 1993. That is my prayer. The state has not answered or catered as to why my names were left out or whether I fulfill the criteria or not. But the orders of provincialization, my lord, would indicate that all the schools of the petitioners were provincialized or were recognized prior to year 1991, as has been indicated before this honorable court. And on that count and count alone, the petitioners who have approached this court should get the benefit of provincialization like all similarly situated individuals in the state of Assam who had been benefited under the policy of 1993. That is my submission, my lord. And regarding the submission, my lord, of
Mr. Soto, in the impugn order, it is stated that
yes,
there is no provision in the act.
fair enough, right.
Then how can they grant it?
My lord, the petitioners were provincialized under the 2011 Act. There is no dispute to that fact, my lord. But the fact remains that the petitioners' rights to have approached this court on prior occasion, it flew from the policy of 1993. That the writ petition in the year 2011, my lord, was withdrawn and the assurance of provincialization, but not from on the date from which the provincialization would come into effect. At that point in time, 2011 Act was the relevant act in question, which could provincialize the services of the petitioners, and they were provincialized. But my grievance lays and still survives to this day on the fact that my provincialization ought not to have been carried out under the 2011 Act. 2011 Act, as has been used to provincialize my services, has something which has been manufactured by the state at an eventual date. My rights flow from the policy of 1993. In fact, my lord would see when the order dated 17/2/2004 was passed, there was no 11 Act in question, man. The 2011 Act was non-existent at that point in time. But the Honorable Court had still entertained the matter and directed the state to carry out examination on whether we fulfill those parameters. Then thereafter, pursuant to that order of the Honorable Court, there was a communication at page 38. Even when page 38, the communication was preferred between the high government functionaries, my lord, 2011 Act did not exist. So what the state has effectively done is that the state effectively, without answering the question of my eligibility under the policy of 1993, had accommodated my case under a subsequent act and thereafter had taken the leverage of that act to say that I could not be provincialized from 1993. So the ground of the 2011 Act not having a consequential benefit clause is an invention by the state. That is not to be disputed because the act is clear. The act has subsequently been repealed also. So they waited till 2013 to take coverage of an act to provincialize me with a defense rider that I could not be provincialized from an anterior date. Whereas the rights of the petitioners had flown from 1993. This Honorable Court, prior to the passing of the 2011 Act, had entertained these matters twice and directed the state to carry out the investigation. The state had not carried out an investigation, or they have stopped short of answering those investigations. The only answer that the state has now come up with is that the 2011 Act cannot accommodate the case of the petitioner without answering whether as to the reason as to why I was left out. In fact, my lord, I have on the case law, my lord. My lord, this order, my lord, rendered by the Honorable Supreme Court. Paragraph, the facts are different, my lord. The facts are regarding emoluments and pay benefits of railway employees. Your lordship will kindly come to paragraph number 24, which, subject to your lordship's final consideration, applies to the case at hand, my lord. Paragraph 24. In many of these decisions, the expression vested rights or accrued rights have been used while striking down the impugned provisions which had been given retrospective operation so as to have an adverse effect in the matter of promotion, seniority, substantive appointment, etc. of the employees. The said expressions have been used in the context of a right flowing under the relevant rule, which was sought to be altered with the effect from an anterior date, and thereby taking away the benefits available under the rule in force at that time, which was the policy of 1993. It has been held that such an amendment having retrospective operation which has the effect of taking away a benefit already available to the employee under the existing rule is arbitrary, discriminatory, and violative of the rights guaranteed under Articles 14 and 16 of the Constitution.
No, before the 2011 Act came into force,
Yes, my lord.
what act was prevailing at the relevant point of time?
2003, my lord.
2003.
Service rules. Yes, my lord.
Whether such benefit is provided in that act?
My lord,
2003 Act.
that my learned friend for the state might be able to better answer that, my lord, because my line of submission before this honorable court is that the provincialization which was affected to the petitioners did not flow from a act or a rule. It flew
No,
from the policy, my lord.
Your service has been provincialized under the
11 Act.
2011.
11 Act, my lord.
Then their contention is that no provision is there
For
giving benefit.
benefit. Yes, my lord.
Date of recognition.
Date of recognition, my lord.
Now the question is whether such a provision is there in the 2003 Act.
My lord, if I have to submit, my lord, without going through the relevant provision, I understand, my lord, that there are no consequential service benefit clauses in any of the
Then
education.
What act was prevailing in
2003,
year
2003.
in the year 1993?
At that point in time, my lord, if I'm aware, it's 1987 rules in the year 1991. In the year 1991,
87?
1987 rules, my lord, provincialization of. Deficit under employee gratuity pull to over 87 নহয় ন
72 এখন আছিলে
এখন নাই
2003 এখনত নাই নেকি
এবাৰ চাওক
ডাঙৰ কিতাপখন নাই নেকি
এইটো provincialization আপোনাৰ মানে দি আসাম সেকেন্ডাৰী এডুকেশ্যন মিডল ইংলিছ স্কুল নহয় এইটো নহব এইটো নহব এইটো এয়া হৈ ভেঞ্চাৰ হয় ন এইটো নাই নেকি
এখনত নাই
নাই ন নো মাই লৰ্ড দিছ ইজ not here.
এখনতো ট্ৰাক কৰিব
So 11 Act was subsequently struck down. Nothing like it.
এখন 72 আছিলে 72 পিছত তোমাৰ হেৰি হ'ল 2003 ইয়াতে নাই এই পুৰণা কিতাপখন
ডাঙৰখন নেকি
এই যে বৰ্মনৰ কিতাপখন বৰ্মন নেকি ইয়াৰ আগৰখন আছে
এই চিঠি
Malord,
কোনো হলো এখন তো ছুটি এখন
no, no, no. Hello?
secondary education provincial classes to 2000 secondary yes 2006
No, no.
elementary Monday.
No, my lord.
Completed.
My lord, I, as a,
Adjourn the matter.
my lord,
We will adjourn the matter.
my lord.
Heard Mr. Anthorpa, Lord, the petitioner. Mr. P. Third, Lord, let's get into the part. It's for PTC. And you for finance. Ardent part, this is the matter of.
Last week of November.
Thursday.
My lord, agreeable.
Tuesday, Lord, coming to
Thursday I have some discussion
typical
next week my lord anything
Tuesday, then.
Tuesday, my lord, Tuesday. I'll have the answers, my lord. 18.
apply
Item 7. May it please, your lordship. That's it, matter.
Yes,
Matter pertains to selection and appointment of assistant professor, your lordship. Lordship, last occasion, respondents were directed to file, respondent number 5 and 6 were directed to file their affidavit, your lordship.
But the counsel for the college was there, my lord. He was supposed.
Their affidavit is necessary, your lordship.
they have accepted notice 5 and 6.
But Mali is there, my
I am representing 5 and 6. I am filing the affidavit to them. I'll start the copy
Today,
today. If you ready, I will start the copy on the current pen right now.
Listen, we have not received the copy, your lordship.
let it be come in the copy, first week of December.
Monday.
That may be fixed, your lordship.
Okay. Heard, Mr.
Our Boro lordship. Our Boro lordship.
Our board learned complete for the petitioner. It's a Hazarika for respondent number 5 and 6. It's a S das for respondent number.
1, 2, and 3, my lord.
1, 2, and 3.
1, 2, 3, and 4.
1, and 4. So Hazarika submits that he will be filing affidavit in opposition for the respondent number 5 and 6 during the course of the day.
My lord.
Accordingly, it is provided that this is the matter in the
On 9th December?
9th of December.
I'm obliged.
Obliged, your lordship.
The affidavit to be filed by Mr. Hazarika for the number 5 and 6.
Obliged.
Obliged.
Please, your lordship. My lord, here, the petitioner's father had donated a plot of land, my lord. That is, in the year 1979, 3 bighas in the name of Union High School, Dalugram, for its establishment, my lord, in view of the welfare of the neighborhood for educating the children, my lord. But at that time, my lord, the school authorities have given assurance that they will keep one post, my lord, reserved for the family member of the donor, my lord. So in 1987, the school was provincialized, my lord. Later on, after my lord attaining majority, the my lord petitioner He has applied for a post of LDA, my lord, after obtaining necessary qualification. And subsequently, there was a, my lord, SMDC, there was a resolution. Your lordship may kindly see annexure B, my lord.
Annexure?
Annexure, my lord. B is the letter, my lord. Kindly, first your lordship may kindly say annexure B. Page
Oh, here
14.
the-
my lord. This is a letter by the headmaster of the school to the director, my lord. Prayer for special consideration to appoint Mr. Ali Hussain, so and so, after creation of one post of LDA, the son of Muzamil Hussain, main donor as per former headmaster of the school, sent up proposals as copy enclosed as prayed for. In addressing you in the subject, I have the honor to state the following few lines. That's Union High School, Dalugram is a 5-class co-educational composite high school located in a remote corner, a backward area of Kachar district. It has become a HSLC examination center in 2003. The school has high enrollment and the workload has also become very heavy to handle only by an office assistant. Under these circumstances, the former headmaster of the school sent up proposals for second post of LDA to the proper authority frequently, while letters attached herewith with a request to appoint the son of main donor of the school. But unfortunately, that was remained unfulfilled and the school is badly suffering till this date. Hence, I do hereby again fervently request your honor to kindly create a post of LDA and appoint Mr. Ali Hussain, main donor of the school, as per former headmaster and close sent up proposals there in the meeting, the problem of the school. Under the circumstances, I would like to request your honor to look into the matter personally and make favorable order, please, so as to enable the schools run smoothly. So after that, a resolution was adopted, my lord. The next page, my lord. Annexure C, page 16. Resolution number 1 to discuss the prayer of Dona Mujamil Hussain, the ex-SMDC president come landowner of the school regarding a resolution over his demand for a post of LDA against the prevailing vacancy of the school. Subsequently, my lord, after this resolution, nothing had happened. Then again, my lord, annexure D, page 21, my lord. The petitioner's father again, my lord, made a representation before the director to the, my lord, inspector of schools. That, sir, at the time of land registration, I appealed to the then managing committee to reserve a post for any family members when my children became eligible, and accordingly the committee gave verbal assurance. But during the time of provincialization of the school, my children were underage and so escaped the opportunity. Yet I have been waiting for better opportunity. Now it is observed that the post of LDA is lying vacant, in which my younger son Ali Hussain BA BCA may be considered deemed fit. Then thereafter, again, there was a resolution by the school committee, my managing committee, page 22, my lord. Then again, they discussed the appointment of the, my lord, petitioner, my lord. That is the relevant portion, page 23, my lord. The type portion, my lord. In the miscellaneous, this at the bottom. In the miscellaneous discussion, one of the SMCA meeting proposed that the landowner desired a resolution on the help rendered by his son Ali Hussain in the official work on computer whenever he was called for endeavor to bring an appointment in the school. The meeting discussed and decided that the government had banned honorary appointment in the year 2005. The school was unable to do it, but his help in the school since the retirement of former OA in 2018 had to be recognized, but the school has no objection if possible to bring any appointment against the vacancy, considering his dedication towards the school as a donor of the government of Assam, by the government of Assam. So it remained like this, my lord. It is the petitioner is working in the computer section as a helper, my lord. Here, the respondents have filed the affidavit, my lord, and I have also filed my reply, whereby I have also annexed the, my lord, deed whereby the land has been donated, my lord. So my humble prayer is that the one post is lying vacant till date, my lord, grade 4 post. And my lord,
But madam, very recently, Supreme Court has pronounced a judgment that no post can be given for donating land.
at least, my lord, due weightage may be given at the time of regular appointment, considering the, my lord, that fact that he is rendering service on without any, my lord, salary,
Yes,
my lord,
Mr. Sharma, what is
and
your
also
stand?
as a son of the donor, my lord.
My lord, the school was provincialized in the year of 1987.
1987.
Yes, my lord. As
Right.
per statement, as per averment made in the writ petition.
Pardon?
And my lord, thereafter, my lord, the complete scenario or completely appointment or any fill up the vacancy is goes under the jurisdiction of the government.
Hmm.
And my lord, thereafter time to time the appointment, the mode of appointment has been changed. Now 2018 appointment has come out, and according to that appointment, my lord, some criteria is laid down, my lord. And regarding the donor of land, there is no option, such option, my lord, here.
Hmm.
And moreover, here we have filed our affidavit in opposition, my lord. And in that affidavit in opposition, we have clearly stated that now the grade 3 and grade 4
Your affidavit.
examination is conducted by the Assam Direct Recruitment.
No, Mr. Sharma, your affidavit is at page number.
Yes, my lord. My lord, page number 30.
30.
Yes.
Who filed the affidavit? Respondent number 3.
Yes, my lord, it is respondent number 3.
Where you have mentioned it?
Para 5, last line. But unfortunately, the office has to mention that the vacant post mentioned in the writ petition has already been filled up by the government of Assam through Assam Direct Recruitment Examination 2022. And subsequent appointment order from Office of the Inspector of School, CDC Silchar, dated 25/5/2023. And my lord, paragraph 6, no vacancy post is lying vacant. It has already been filled up by the government of Assam through Assam Direct Recruitment Examination 2022. Furthermore, the resolution adopted by the SMDC meeting on 24/6/2020 outcome findings shows that the petitioner has mentioned about the vacant post of is no longer vacant. It has already filled up.
Okay. But you are not disputing that the father of the petitioner has donated a plot of land to the school.
My lord, this was prior to the provincialization, my lord. After provincialization, my lord, it is come under the purview of the government, my lord. And the school have to follow the norms of government regarding the appointment or dismissal or anything.
Hmm. Okay, we will see what kind of relief can be granted. We'll pass.
He is now not entitled to get any relief, my lord. Because, Hmm. Well, regarding the provincialization, no, that's- my lord, I want to point out the recent relevant act regarding the non-teaching staff of Dancer Education Institute. After some time, my lord.
So Sarma,
Yes,
it is in your affidavit.
yes. No, it is not. My lord, regarding our affidavit, my lord, annexure 1, page 33, my lord. And relevant portion is there. On page number 3 of the gift deed, it is mentioned by the donors that they have no any further use over the land. They have no claim and objection over the land in future until an otherwise union high school Dolgram Kasar is either closed or shifted elsewhere.
That is, my lord, as per the deed, my lord. They have donated the land. That is why these lines were, my lord, there, my lord.
Okay.
And my lord, as per our Act 2018 regarding the provincialization of services of non-teaching staff and Vansa Education
Sarma,
Institute.
you have already mentioned it in your affidavit.
It is not mentioned, but it is a relevant act for recruitment of the LDA, my lord. So regarding qualification.
And here till date, my lord, the petitioner is rendering his service as a helper in the computer sector. They have been utilizing his service since long, my lord. Till date, they have been utilizing his service, my lord. And they have admitted it in their resolution, my lord.
My lord, to get the appointment, he has to follow the proper procedure regarding the, he has to fill up the form to get,
Yes, my lord.
get the.
He will do that, my lord. At least
In the interview, my lord.
due weightage may be given, preference may be given, considering his, my lord, the fact that he is, that land had been donated by his family and also he has been rendering his service, my lord.
Okay.
Moreover, requisite qualification is required.
Qualification is there, my lord, requisite qualification. Obliged.
PGC has suggested, my lord, the experts be included in the committee. He's a professor of AIMS, my lord. They have suggested as an expert on behalf of the UGC.
Ex-additional officer.
But whether he is expert in academics, like
Medical education in the Department of Microbiology. And your lordship will add the experts from the Assam University because the Assam University is the only university having the microbiology department in the state of Assam.
And maybe professors from the Guwahati University in the Department of Life Science, Zoology, Botany, and Biotechnology, all
What university, no life science department.
life science is there, but the microbiology department is independent. There is no independent department of the micro.
Life science is there. in
Life
what
science is there.
Is it?
Yes, life
Are
science.
you sure?
Yes, zoology, botany, they are all nowadays life science.
But there are separate departments.
Yes, separate.
Botany, zoology.
Microbiology, there is no separate department, my lord. Only 10 students on outsourcing their private.
No, but if we include this person, whether the purpose will be served.
He'll be nominated as, or he'll act on behalf of UGC. Other experts will be there. In addition to him, other experts from this university level has to be there. Subject experts, life science subjects, and microbiology subject experts from the university level has to be there.
We'll talk about that.
And my lord, regarding her appointment, that has not been cancelled by the inspector of schools, my lord, and it is Captain Evans. So, my lord, my humble submission will be there, my lord, as after the outcome of the committee's opinion, my lord. If it is in my favor, in that event, I may be allowed to continue.
Okay, we'll talk about that.
Humble.
Please, Lordship. My lord, I have checked it up, my lord. Basically, my lord, I have not been sent up for the trial, my lord. I have obtained the copies, my lord. Type copy also as well as vernacular also. And in the criminal case, my lord, investigation, my lord, after completion, my name was not sent for trial. Only other person. First is the type copy, my lord, and next one is the vernacular.
So the final report was not accepted by the.
No, not given, no final report. And the charge sheet, my lord, lordship will see page 35 for a moment for clarification of my writ petition, my lord. Lordship, kindly turn to the page 35, operative part of the charge sheet, my lord.
It was not submitted against it.
No, my lord. Lordship, that's why, my lord, I like to insist upon lordship come to page 35 of the writ petition. Only operative part of the charge sheet I am reading, my lord. During the investigation,
No, okay. Madam, you were correct.
during the investigation, prima facie case under section 120B, so and so has been found, established, arrested, accused persons Rajiv Kalita, son of so and so, number 2, Madhusudan Kalita, then number 3, Manik, number 4 is the Bipul Das. Then, Lordship, I beg to send them for face trial in the court of law. Further, I beg to report that the course of investigation, there is no factual evidence found against the other accused Kandharpo Deka. This is the instant petitioner. Son of so and so, so and so. So may kindly be exploited from the liabilities of the case. So I have not never sent for trial. And by page 51, my lord, I have approached to the authority, my lord, along with the application with a prayer, my lord.
Page,
Page 51, my lord, is the type copy, 52 is the vernacular. Beg to state that the Tihu police station case now I was suspended by order issued by Director so-and-so. Assam, I was reinstated after joining my service. I am discharging my duty. Though I am receiving my salary, post was not regular, taking regular salary. It is informed that in the case of investigation did not find and submit the charge sheet against me. I have received character certificate from Honorable so-and-so. Therefore, enclose the certificate with the cancellation of the suspension. Reinstated everything, my lord, only
when
TP is
it was reinstated.
reinstated, my lord, lordship will see at page. I have been reinstated, my lord. Uh, Page 18,424. Page 50, my lord. That is 18 April 24.
So now you are working.
I'm working. I'm basically agree with the departmental proceeding, my lord, which has been issued to me, my lord, page 47 and page 54.
47 and 50.
54. In the light of that, my lord, the departmental proceeding has to be quashed, my lord. There is no material, nothing.
No. Is there any rule or law in that regard?
My lord, since my lord, the case has been nullity of law, my lord. Criminal case, it has become nullity against me. So question does not arise, my lord, for departmental proceeding.
No.
If departmental proceeding, when comes, my lord? If I have done anything wrong, I have prosecuted or anything, 6-1, nothing has such. Since there is no case against me,
You were challenging.
I am challenging the departmental proceeding initiated against me.
53.
My lord, page 47 and 54.
54. So, Mr. Barmuya,
Lordship,
whether the departmental proceeding cannot be proceeded with in the event of filing a final report against you.
no, my lord, final report, it is not a final report. I'll just clarify last day, my lord. It was
Final
mispronouncement.
report means a final report.
My lord,
against
nothing has been
against
found
the-
against me. Nothing found against me. Out of
Yes.
5,
That's why they have submitted final report against.
no, my lord, no final report, my lord. I have not been against them. They have been charge sheeted and my name was not sent for trial.
Final report means they have found
My lord,
nothing against.
implied meaning is that, my lord, that I have uttered on the last occasion, since police did not find anything against me, there must be some final report. But charge sheet reveals, my lord, they said, my lord, there is no material against me. So my name is to be excluded. It is there, my lord, from the charge sheet itself revealed. Just now I have
Final
shown
report against you.
no final report, my lord. They have said to expound my name, my lord. I have not been charge sheeted, my lord.
No. Not subjected, it is all right.
Lordship.
But the final report is submitted.
No, my lord, there is
This
no
is
final
against
report,
you.
nothing as such. Other accused for them charge sheeted.
Yes.
For me, they said their name to be excluded.
So therefore, there is final report against.
No, my lord, there is no separate any, I have checked out.
That's all right. In the same.
But
same
implied meaning, my lord, if the consideration of the law, it seems to be, my lord, something has to be there. But police, what they said, my lord, just now I have shown your lordship's attention at page, my lord. Type copy, I just now I have read out, my lord. The
No,
But-
Mr. Pornia,
lordship,
can you show this court any decision?
decision,
either
my
High
lord,
Court or Supreme Court that in the event of closing the criminal case, the department cannot.
Sir, lordship,
against,
another,
against you.
yes, that I'll check it up, my lord. Lordship, again, I draw to attention at page 47, my lord, for a moment.
Yes.
I'll just read out, my lord, page 47. You are hereby required to show cause rule 9 so and so disciplinary appeal so and so. The penalty is prescribed under so and so. While you are serving an assistant teacher PNBC so and so, Tihu police station number so and so, DO so and so bail application. You should submit your written defense within 10 days and written statement so and so. And statement of allegation, lordship, kindly see why departmental proceeding will be initiated. Now, lordship, bottom 47 page be seen, my lord. While serving assistant teacher as an assistant teacher PNBC under Nalbari district, you were arrested in connection with so and so, so and so. This is the only ground. Police said, my lord, though they have arrested me, my name has been already removed from the charge sheet. Even though, my lord,
Now, Mr. Borgoya, you show me the decision. If any,
I have to
That,
check it up, my lord.
you check it up, I will give you time. We keep the matter as perfect. You
Plus,
show me the decision.
decision, my lord, in the light, my lord, whatever I checked, I did not get. The core issue comes, my lord, Assam disciplinary appeal rule. There it said, my lord, penalty is provided under section rule 7. But here is, my lord, no case against me.
No, that's all right, we'll see.
No case against me, my lord. This may be the first time, my lord. Can be a precedent for future course of any
No,
case.
no, there are some precedents.
My lord, I
You-
did not get, my lord.
Check it. Yes, so what is your stand? Pardon?
Sometime with the updated instruction from the department.
What updated instruction you required?
Or, my lord, they can do one thing, my lord. Subject to your lordship's convenience, my lord, that I have approached to the authority by page 51, what action has been taken. That will suffice the problem, my lord. Page 51, my lord, particular is the page 52. And in the meantime, lordship will stay the
No, the suspension order has been stayed.
state, my lord, lordship kindly see, my lord,
No, no,
what they,
already revoked, you have been.
yes, I am revoked, my lord. It is informed that the case of the investigation did not find submit charge. I received the charge certificate from the honorable, so no cases against me. Therefore, close certificate along with the cancellation of the suspension. There, my lord, I have annexed cancellation of suspension, meaning thereby revocation of my suspension. Now, my lord, let them take instruction what they did. Or if the prosecution is to be gone, to be governed against me under what provisions of law. In spite of my lord. Suspension to উঠাই দিছে গন না না এটু নেক্সট করিছে টু কি ওই তো ওটা ডিবি ক্লোজ ওর জাজমেন্ট কো জানো জাজমেন্ট কই বেরতে কেসি না If there is a, my lord, any charges leveled against me in criminal, there is a judgment.
No.
Now question, my lord, no case is been made out against me.
You check if there is any decision on this point.
And let them take instruction also, my lord, what is the fate of the departmental?
No, Mr. Portnia, you see, it is page number 51.
51, it
There
says,
is
my
no-
lord, regulation may not be the correct language.
For cancellation of suspension.
No, there, my lord, prayer for withdrawal of the departmental proceeding, my lord. Subject lordship, kindly have a look. Page 51, prayer for withdrawal of the departmental proceeding for regularize of service. Vernacular, too, I cannot read. It is prohibited.
No, Mr. Portnia, in this regard, he has produced one report of the elementary education director.
May I have a look, my lord?
Yes. What is a copy to? him? So we'll fix a short date. Yes. You come prepared on that point.
My lord, that, to be very honest, my lord, I checked it last night also. I got, my lord, on rule 7, rule 9, but here is, my lord, neither rule 7 nor rule 9 can affect me by virtue of the nothing found against me by the criminal.
Even then, again, check it. We'll
Okay, my lord, I'll check it.
Heard Mr. Portnia, learned it. What of it? And open learned something.
The order copy which I have supplied, my lord, be formed as a part of the record. I have supplied two
Yes.
copies, my lord, be kept as a part of the record.
Okay. There is the rules of deliberation. Portnia has produced one copy of order passed by the civil junior division come there. They
Over that,
have
is
seen
a
the
court order
order.
discharge could not. Yes. What
They
court
say
of given
more
order?
than the form that is that book on garden. The next object for the content different department that for the effect of the director elected it. Dated 19th of August. The order for the court shall be taken with the record. And the copy of letter dated 19th of August 2025 the part. Portnia learned of the court of and rest is a list of letter of 20. In the meantime, is open learned council. Standing council for the
Is
response.
the regular?
Elementary officer departments have obtained instruction in respect of the representation filed by the petitioner on
20 na 27 तारीख में
19/10/2024.
May I?
To the director, sorry, to the deputy inspector of school Nalpat. This is the method.
May I interrupt? My lord, this letter addressed to the senior Senate party. Can I furnish?
Yes, pardon me. Where is the fire?
There is no hide and seek, my lord. Everything is, my lord, not like other,
Yes,
everything. Anyway, my lordship fixing matter on 2020.
20.
So lordship, can it give some more time, my lord?
Okay.
2020, lordship fixed matter on Tuesday. Can it be, my lord, 25th or 25th, my lord,
25th. Okay, all right. 25th.
lordship? November, my lord.
Really possible for timing, Lordship.
No, here, Lordship, we have already filed an affidavit in opposition yesterday, Lordship, because not take with the record. And there's, I have been told by Mr. Asborn, they are going to file a reply.
Lordship.
Okay.
Yes.
You received that copy.
We have received the copy, Lordship.
So let it come next week, Lordship, along with,
Want to file a reply.
Reply, Lordship, yeah.
next
File
week.
your reply. Heard, Mr.
US Bora.
Learned counsel for the petition of Mr. has this is the learned counsel. Part. The learned counsel for the petitioner submits that they will write a reply to the affidavit in opposition filed by the respondent in secondary court. Accordingly, it is provided that the list the method in the first week of December.
Yes. Can you fix the date, Lordship? The date may can be fixed.
5th December.
Obliged.
Obviously.
Item number 20, order letter.
May I please, your lordship.
My lord, matter may be taken up
After some time.
after some.
21.
Also in 21, we should have some time lost. Thank you.
None appears for the petitioner on call, however, Mr. Applicants are not heard. This after 1 week, the event of subsequent non-representation of the petitioner advocate orders have followed. Item 22.
May I please, your lordship? My lord, my grievance, my lord, my grievance is that, my lord. Five,
Time to file our affidavit.
my lord,
Pardon?
Some time to file our affidavit. We have not filed our.
my lord, may I submit, my lord?
You are for respondent number
Five.
5. You for 1.
May I submit, my lord, one thing, my lord?
Yeah.
My grievance is that, my lord, including me, my lord, five, my lord, child, my lord, conflict with law were, my lord, apprehended by the, my lord, police, my lord, and all of them, my lord, granted bail by the landed court below, my lord, and three child, my lord, conflict with law, my lord, were allowed to attend their classes, my lord, except me, my lord. So, my lord, that is my lord, humble submission, my lord. So I may be allowed to, my lord, attend my classes because three others, my lord, already have been allowed, my lord. My lord, one forwarding, my lord, all of them were arrested, my lord. So, my lord, kindly turn to pay order of my order 13/10/2025, my lord, of this petition, my lord. There is, my lord, notice was issued on interim prayer also, my lord. Order, my lord, 13/10/2025. Last line, my lord.
Maintainability of this petition also. We are a private investor.
Private institute.
Actually, 3 weeks time, also will take the instruction and file our affidavit.
My lord, that may be filed, but in the meantime, my lord, I may be allowed to attend my classes, my lord.
No, first we have to ascertain whether this petition is maintainable or not. They have raised the issue.
Then, my lord, a short date may be given, my lord, because, my lord, my
Heard Mr. Sikdar, Garden for the petitioner. Mr. Gogoi for respondent number 5. 5. And Mr. Upamonya for 3 and 4. Then for UGC. Your name, please? B. B. Rava. For respondent number 1. Mr. Gogoi submits that he may be granted some time to file affidavit in opposition. Mr. Upamonya, are you interested to file your affidavit? Not necessary.
but it is under UGC, my lord.
Whether this university received any grant from the government or not, that information you can obtain.
It is functioning under, my lord, UGC, my lord.
Maybe. But it is a private institute.
It's run by society. It's run by society.
Prayer of Mr. Gogoi is allowed. Place the matter after 1 week.
2 weeks, my lord, kindly 1 week, my lord, because my session will.
Okay,
go, my
after 1 week.
lord, kindly fix a date, my lord, kindly, my lord.
Okay.
My lord,
But for
I'll do bless, I'll do bless. May I please your lordship? They have filed an affidavit, your lordship. The issue, your lordship, in this particular case is, your lordship, like this. The petitioners here in your lordship are all aspirants for your lordship, graduate teacher, maths, your lordship, post of graduate teacher, assistant teacher, graduate teacher, maths, your lordship. Your lordship may kindly come to page 29, that is the advertisement, your lordship. This advertisement is dated 26/12/2023, your lordship. By this advertisement, your lordship will get, your lordship, initially, your lordship, there's a filling of 7249 vacant posts of graduate teacher arts, graduate teacher science, graduate teacher Hindi, and graduate teacher Sanskrit. This advertisement was issued, your lordship, at page 29, your lordship. And minimum educational qualifications were also there, your lordship. But subsequently, your lordship,
Mr. Portacore
lordship,
will resume after 5 minutes.
lord, lord. May I please, your
Mr.
lord,
Portacore.
lordship. Page 29 is the advertisement, your lordship. They have sought to fill up 7,249 vacant posts of graduate teacher arts, graduate teacher science, graduate teacher Hindi, and graduate teacher Sanskrit, your lordship, and minimum education qualifications, etc. were given, your lordship. Now, your lordship will kindly come to page 35, your lordship. Page, your lordship, 42, your lordship.
Page
42. Your lordship will find there is a they have, your lordship, given the number of candidates that selected in each category. Your lordship will kindly come to serial number 2, graduate teacher mathematics, 17,737 numbers of posts, your lordship. We are concerned with this, your lordship. Now, your lordship will find the qualification for graduate teacher maths is given in this particular addendum, your lordship. Earlier in the advertisement, it was not given, but in this addendum, it was given. Serial number 1, your lordship. I am reading, your lordship. A graduate teacher mathematics shall have a graduation degree in science with honors or major in mathematics and having physics, chemistry, or biology as pass course or minor subject in the graduate level course. We are not concerned with this, your lordship. Next part, your lordship. Or post-graduation degree in mathematics from a recognized university with honors or major in mathematics having physics, chemistry, or biology as pass course or minor subject with at least 50% marks in either graduation or post-graduation. Now, your lordship, reading of this particular qualification, your lordship, makes it abundantly clear, your lordship, that if a person who wish to be appointed as a graduate teacher maths, your lordship, he will have a either graduate degree in maths or postgraduate degree in maths, and along with that, he must have, your lordship, the maths as a honors or major subject in the graduation, your lordship. And prior to that, your lordship, issuance of that, your lordship, since it was not part of the rule, your lordship, just before that page 41, your lordship, they have amended the rule also, your lordship, it was included in the rule, page 41, your lordship. The qualification of the mathematics. In the principal rule, amendment of 2, schedule 3, in the principal rule, in schedule 3, clause 2, in the last line for the punctuation mark appearing in the end of the punctuation mark shall be substituted. Thereafter, the following proviso shall be inserted. Provided that a graduate teacher mathematics shall have a graduate degree in science with honors or major in mathematics and having physics, chemistry, biology as pass course or minor subject in the graduate level courses or postgraduate degree in mathematics from a recognized university, which honors or major in mathematics, having this, your lordship. Major in, your lordship, mathematics is a must, your lordship, whether you have a graduate degree or a postgraduate degree. Apart from that, you will have to have physics, chemistry, biology, one of those subjects as pass course, and 50% marks, your lord. Now, your lordship, in view of that, your lordship, and that your lordship will kindly come to, then your lordship, the SOP, your lordship, after your lordship, page 101, your lordship. That is the standard operating procedure for verification of the mark sheets and documents issued by the Director of Secondary Education, Assam, your lordship. And your lordship will find the documents to be verified by the Inspector of Schools. It starts from, your lordship, page 102. And serial number 15, your lordship will find 103 at page 103, relevant paragraph clause. In case of graduate teacher mathematics, candidate must have a graduation degree with major in mathematics and must have physics, chemistry, or biology as minor subjects. The mark sheet certificate need to be verified by the Inspector of Schools. Now, your lordship, apparently from the SOP itself, your lordship, and your lordship, one more page, your lordship, I will rely, your lordship, will page 114, your lord, 113, your lord. This is the, your lordship, form that needs to be uploaded in the website, your lordship, application form, your lordship. Now, your lordship will find, your lordship, in this graduate teacher, your lordship has seen the tick mark portion, graduate teacher mathematics, your lordship. And second, your lordship, first, your lordship, do you have honors or major in mathematics having physics, chemistry, or biology as past course or minor subject? And then, do you have post-graduation degree in mathematics from a recognized university with honors or major in mathematics, your lordship? Now, your lordship, what they did, your lordship, they have, your lordship, call for the verification certain candidates, your lordship. Some of them are, we have named, your lordship, and their name has found, according to them, they are named in the main select list, your lordship, that they don't have the major in the degree course, your lordship. They pursue general course, your lordship. Subsequently, in universities like, your lordship, USTM or others, your lordship, they have did their post-graduation, your lordship. So they were also called for the verification. And secondly, your lordship, their documents are verified, and ultimately they were, according to them, selected, your lordship. Since, your lordship, there is no publication of the select list for all, we have also filed their RTI, they have not provided to us, your lordship. So, your lordship, we came to know that these people are, your lordship, at least these named, those who were named as a respondent, your lordship, they were selected by them, your lordship. Now, your lordship will kindly see, they have relied on in for as a justification, your lordship. Sorry,
File.
affidavit, affidavit, they have filed.
Otherwise, no notice has been issued, private respondents are yet to get the notice, lordship. Mean, their allegation against the private respondents, notice yet to be received to them, issued to them.
Okay.
No, your lordship will notice, since I have a prayer for interim relief, your lordship, that these candidates who were named, your lordship, they should not be, if your lordship will kindly see, if it is, if your lordship prima facie satisfied that, your lordship, this calling for the interview and their selection is against the rule, your lordship, as mandated by them, your lordship, that will probably, your lordship, I will be entitled to, your lordship, in my humble submission, your lordship, for an interim protection, and your lordship will kindly.
Without hearing any order.
But if your lordship allows them to join, your lordship, in the selection and post, that in violation, if their selection is prima facie, your lordship, in violation of the rule, your lordship, then, your lordship, what will happen? Your lordship will kindly see, they have relied on page 48, your lordship.
No, let us do one thing. We will make an observation that their selection and appointment is subject to
Outcome,
outcome.
yes, Lordship, yes, that can be done.
That will serve your purpose.
That can be done, your Lordship, but
But
ultimately,
without hearing them, granting them relief.
yes, normally your Lordship is, your Lordship, if your Lordship.
Need to call prejudice to them, Lord.
If your Lordship is not prima facie satisfied that I don't have a case, your Lordship, then your Lordship is a different matter, your Lordship matter. But normally your Lordship passes such order, your Lordship, if your Lordship satisfied.
Mr. Board Member, do you have anything to show that those respondents do not possess the honors degree, sorry, BSc honors in mathematics?
Yes, yes,
Yes.
I have, your Lordship.
Yes.
Your Lordship, I have annexed certain documents, your Lordship. Your Lordship will kindly see page 122, your Lordship. This is one of the
From-
candidates, your Lordship.
From where you have obtained those?
I have obtained through RTI, your Lordship. I have made a statement, your Lordship, from those universities.
Number
your
one,
Page 122. 120 is the RTI application, your Lordship. And then 122 is the, your Lordship, his mark sheet. It shows, your Lordship, course, your Lordship will get, your Lordship. BSc 6th final semester, course general, your Lordship. Chemistry, mathematics paper 2. It's a general course, your Lordship. It's not major. And your Lordship, in the additional affidavit, I have brought few more, your Lordship, to show that they did not pursue their graduation in with major in mathematics. Rather, as your Lordship, they are part of the general course, your Lordship. And your Lordship will find the additional affidavit I have filed earlier, your Lordship. Our additional affidavit. There is an additional affidavit we have filed, your Lordship. That again will show, your Lordship. There, your Lordship, 3 other persons, your Lordship. Page 132, your Lordship will find. One Akhtas Ali, Sikandar, your Lordship. His case, your Lordship, is general, your Lord. And it is not denied by the respondent that, your Lordship, they are from the general category, they have pursued general course, your Lordship, not mathematics as a major, your Lordship, in their affidavit, your Lordship. What they say, your Lordship, that relying on 4/1/2025 notification, your Lordship, they are saying that the requirement of major is not there for appointment as graduate teacher maths. That is their statement, affirmation in the affidavit, your Lordship. They have filed their affidavit. They have not denied.
Page 127, Lordship, may kindly peruse.
Page 127, their
Our
affidavit.
affidavit.
Before that, your Lordship will kindly peruse the page para 6, your Lordship. They have
Six of-
complete para 6, your Lordship,
of
of their affidavit, your Lordship. This clarification, your Lordship, what they have said, your Lordship, in this is not there in that particular notification, your Lordship. They says for graduation level eligibility, a candidate must have studied mathematics as a major and physics, chemistry, biology as minor or pass course. For post-graduation level eligibility, any candidate having MSc in mathematics is eligible regardless of whether we studied in graduation or major honors along with mathematics as a minor or pass course subject, your Lordship. That's your Lordship. If your Lordship then take up that 4/7/2025, that is at page 48, your Lordship will find. Page 48, your Lordship. That is a clarification issued by the Secretary of Assam.
Yes.
The provisions stipulated in the amended second paragraph, your Lordship. The provisions stipulated in the amended Schedule 3 of the Assam Secondary Education Professional School Service 3rd Amendment Rules 2024, the following proviso inserted. Provided that a graduate teacher math shall have a graduation degree in science with honors or major in mathematics and with physics, chemistry, biology as a pass course or minor subject at the graduate level, or a postgraduate degree in mathematics from a recognized university with honors or major in mathematics and with physics, chemistry, biology as pass course or minor subject with at least 50% marks either in graduation or post-graduation. Then the department had duly examined the said proviso in the rules. It is hereby clarified that the rule clearly means that a candidate must have studied any one among physics, chemistry, or biology as a pass course or minor subject, along with mathematics as a major honors, Your Lordship. Now, Your Lordship, this clarification itself says, Your Lordship, that mathematics as a honors is a mandatory requirement for appointment to the post of graduate teacher maths, Your Lordship. Wherefrom, Your Lordship, they inferred that there is no requirement. And they have, Your Lordship, in their affidavit referred to this particular notification, Your Lordship, saying that this notification empowers them to appoint them, or clarified to the effect that mathematics is as a major subject is not required, Your Lordship, for those who have postgraduate degree. That is not there in this notification. Rather, it strengthens my case, Your Lordship. Very categorical, Your Lordship, along with mathematics as a major or honors, Your Lordship. Now, Your Lordship, the rule itself says this. Rule, Your Lordship knows very well, Your Lordship. I don't require to point out to this honorable court that, Your Lordship, rules will be, the language is plain. Then we will have to go by the literal meaning of the rule, literal meaning of the words, Your Lordship. Rule will have to be interpreted in this manner. There cannot be any ambiguity. When there is an ambiguity, there can be a, Your Lordship, question of, Your Lordship, interpretation. Rules are very clear that major in mathematics, even for postgraduate or graduate degree, for being appointed as graduate teacher maths, Your Lordship. That's what rule of interpretation says, Your Lordship. Therefore, in my humble submission, Your Lordship, the appointment selection of these candidates, along if there may be many more, Your Lordship, we don't have any idea, since there is no select list they have publicly made available to the candidates, Your Lordship. Therefore, Your Lordship, at least these candidates should not be, Your Lordship, allowed to be joined, Your Lordship. On the face of it, Your Lordship, their appointment will be in violation of the.
But these respondents, they have pursued mathematics in
As a pass course, Your Lordship.
no, in a postgraduate course.
Postgraduate, they have mathematics.
MSc in
Mathematics.
in
Mathematics, Your Lordship.
okay. So the contention of the state respondent is that
That will be enough, Your
that
Lordship.
will be
Enough. And our
the rule speaks otherwise.
otherwise, that's my contention, Your Lordship. Now, ultimately, Your Lordship will have to take a call, Your
Rules
Lordship.
speak that graduate teacher with mathematics, graduation degree in science, honors in or major in mathematics, having physics, chemistry, biology, pass course, or minor subject in graduate level. That is, so far as graduate level is concerned, or postgraduate level, there is a different law. If the postgraduate level, or postgraduate level in mathematics from a recognized university with honors or major in mathematics, having physics, chemistry, biology as pass course. Now, these private they have mathematics in postgraduate degree losses. In postgraduate degree, they have in mathematics in
Then
postgraduate.
why it is honors in mathematics?
Honors is different thing, losses. Honors is that graduation part is different and his postgraduate is different losses.
No, in postgraduate, but there is no provision for honors.
Yes.
Is it? So why the words are
Pass
there?
course or minor subject or as a minor subject losses.
Which are as a minor subject? Physics, chemistry.
Honors in mathematics, physics, biology as pass course or minor subject.
Hmm.
Otherwise, ultimately they have the mathematics in postgraduation degree
No,
losses.
no, Mr. 60,
Yes.
you come to page number 48, and it starts,
Yes, this is a speaking order issued by, but
Speaking order.
yes, but amendment is at page 41.
Hmm.
Rule is at page 41 losses.
They have relied on this speaking order, Your Lordship, in their affidavit to buttress their argument.
Rule provided with a second amendment of Schedule 3 on 2 was provided that a graduate teacher mathematics shall have a graduation degree in science with honors or major in mathematics and having physics, chemistry, biology as pass course or minor subject in graduate level courses. That is regarding graduate degree is concerned, or postgraduate degree
post-graduation degree in mathematics from a recognized university with honors or major in mathematics, having physics, chemistry, biology as pass course or minor subject with at least
In
50% marks.
graduation or post-graduation?
Yes, Lordship.
No, in post-graduation, the honors is not necessary.
Not necessary. Perhaps the language may be there, Lordship. Ultimately, these private they are postgraduate in mathematics, and as such, they are
No,
entitled.
maybe, but here again you see, having or major in mathematics, having physics,
Physics,
chemistry, or
biology
biology as
pass
pass
course.
course or minor subject with at least 50% marks either in graduation or post-graduation.
Ultimately, notice should go let the
Wait,
private appear and explain their position.
Your
Lordship.
Mr. Sister, you say post-graduation degree in mathematics.
Yes.
From a recognized university with honors or major in mathematics.
mathematics.
Yes.
In postgraduate course, there is no provision for
Or
honors or major.
Major, Your Lordship.
Then he has to, he must have this honors degree in honors in this graduation course.
Graduation course. That is a
Yeah.
if interpretation with in that way, Lordship, let the private appear and explain, Lordship. And in the meantime, let the appointment is not yet made. It is premature that their appointment will be given, Lordship. Lordship, let the subject of the outcome may be of subject of this honorable this petition, Lordship.
This is a notice, Your Lordship, on 13th, Your Lordship, appointment orders will be issued to all, Your Lordship. This is a public notice issued, Your Lordship. There will be, Your Lordship, in veterinary college playground, Your Lordship.
Without hearing the private attorney, if this honorable Lordship, it is P2 to them.
If they feel aggrieved, then they will come by way of a stay vacating
They
application.
will definitely feel aggrieved of
Then-
the an
then-
order was against them.
Then,
without hearing them, Lordship.
then they have their options open by filing an interlocutory
Options
application.
open to the petition also if any appointment is given.
If I have been able to
And this
satisfy this
has ample
honorable
power to Lordship interfere at any stage, even after issuance of the appointment letter, Lordship. So without
I am
hearing-
only relying on one judgment, Your Lordship, on this, Your Lordship, on this. Your Lordship knows very well, Your Lordship, still, Your Lordship, for my satisfaction, para 26, Your Lordship. It says, Your Lordship, para 26 in the middle part, Your Lordship. In the middle part, it is on interpretation of this statute, Your Lordship. It says, it is yet another rule of construction that when the words of the statute are clear, plain, and unambiguous, then the courts are bound to give effect to that meaning, irrespective of the consequences, Your Lordship. That's important, Your Lordship. Para 20, Your Lordship, para 26, Your Lordship, in the middle part, last page, Your Lordship, page 553, Your Lordship. Fifth line from the top, Your Lordship. It is yet another rule of construction that when the words of the statute are clear, plain, and unambiguous, then the courts are bound to give effect to that meaning irrespective of the consequences. It is said that words themselves best declare the intention of the lawgiver. Courts have adhered to the principle that effort should be made to give meaning to each and every word. Only that, Your Lordship. And in that view of the matter, when the rule is very clear, Your Lordship, unambiguous here, Your Lordship. Therefore, Your Lordship, I will pray for an interim direction, Your Lordship.
For Thakur,
Lordship,
if you produce their mark sheets,
Lordship. All of them are through, Your Lordship, RTI, Your Lordship.
but unless the certificate is produced, can it be said at this instance that they have no honors in degree course?
With utmost respect, Your Lordship will kindly see, these are, Your Lordship, we have made a, Your Lordship, categorical statement, and Your Lordship will kindly see, this is the BSc 6th final semester. This was the last semester, Your Lordship, in a BSc category, Your Lordship. Mark sheet of the BSc last semester, Your Lordship. That will reflect everything, and the course general is Very categorically written here, your lordship.
Unless the certificate is produced,
And your lordship, your lordship, one copy, your lordship, that will probably clear it out, your lordship. Where your lordship measure is there, in the certificate itself, your lordship, the measure is written, your lordship. At the top, your lordship will find.
this dates it, not the certificate.
This is not certificate, your- this is again the mark sheet, your lordship, last mark sheet, it's measure, your. When there is measure, it was written as measure, and when it is not measure, it's a general, it will be written as general. This is my case, rest your lordship, I leave it to your lordship. Your lordship. I will pray for an interim order.
All these documents are submitted by the petitioner's lordship. Let the petitioner come then, come with your certificates and all these things in original lordship. Notice to let them take justice service lordship for.
Justice service, it's difficult, your lordship. How can I find your lordship where this person's your lordship are
They
there?
have given the addresses.
Address, I will be,
They have
I will-
given the addresses lordship.
that cannot be your lordship.
All the pet.
There will be many more, your lordship, but the fact that your lordship, they have not published the select list till date, your lordship. And our RTI has not been replied, your lordship, we have not been able to, your lordship, bring.
We have not published the select list. We have not given the appointment. Now they want the appointment to be stopped
They have, what they have done, your lordship,
without hearing them.
everyone, your lordship, will have to, their roll number, your lordship, they will have to click and their result will be out, your lordship. You are selected. But normally, your lordship, a select list is published under this category, these are the persons selected. That has not been done here, your lordship. In a very hush manner, your lordship, these selections were conducted, your lordship. And RTIs are not replied, your lordship. I leave it to your lordship.
Okay, I will pass the order.
Lordship,
They're going through their affidavit.
lords. Deeply obliged, your lordship.
Yeah.
Sorry,
Available.
my lord. My lord, three orders, I am relying, my lord, the first one is Jagannath Pegu, my lord. Dada. Lord, the first one, without title is the Jagannath Pegu, which has been relied on in the various orders and judgments, my lord, passed by this honorable court, my lord, in various cases. My lord, in this case, the relevant paragraph which I could find out, my lord, is paragraph 10, the last page, my lord.
Yes.
May I read, my lord, para 10? It is apparent that the petitioner is senior to the respondent number 4 as a graduate assistant teacher and eligible in terms of the rules for being promoted to the headmaster. In absence of any material on record to justify the impugned order, I am not inclined to sustain the submission made on behalf of the official respondent. Noticeably, the official records pertaining to a decision presiding the issuance of the impugned order is also have not been produced in support of thereof. It is too fundamental to state that a candidate eligible in terms of the relevant rules for promotion to a post on a regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post as in the instant case. In the absence of any affidavit, so my lord, this is the three line is relevant, my lord. In absence of any affidavit controverting the correctness of the authenticity of the statement made in the petition, it is permissible to proceed on the basis that the pleaded case of the petitioner is correct. In the above view of the matter, the petition is allowed. The impugned order being
repugnant to the rules to set aside, the state respondent would take appropriate steps to consider the petitioner case for the charge of the office of the headmaster of the school by meticulously taking note on his service career and the prescription of the rules noticed herein above and pass appropriate order. So, my lord, here is also a case similar to the present case wherein, my lord, a senior person, my lord, who is having the degree of, my lord, the BSc and B.Ed was not given the charge, and the junior was, my lord, offered with the charge of the office. The whole judgment is like that manner, my lord. And thereafter, this honorable court was pleased to interfere with the impugned order, and a mandamus had been issued directing the official respondents to do the needful to hand over the charge to the petitioner, my lord. Now, my lord, this is the come to be a landmark decision, and this decision has been repeatedly reiterated by this honorable court, my lord, in the single judge as well as before the division bench also, my lord. One judgment, my lord, can be pleased to find a single judge order is Govind Sharma, my lord. I have given today also. WPC 2621 of 2022, my lord. My lord, in this judgment, if my lord straight away can take up page 7, paragraph 14, my lord. At this stage, it is relevant to take note of the another decision of this court in the case of Jagannath Pegu versus State of Assam and others so and so, wherein this court has held that a candidate eligible in terms of the relevant rules for promotion to a post on regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post. In other words, for being eligible to considered for ad hoc interim arrangement against a post pending regular selection to the said post, it is only a person who satisfy the eligibility criteria mandated for being considered for promotion to the post on regular basis can only be considered for holding such post on in-charge basis. Any person not otherwise eligible for being considered for promotion to such post on regular basis cannot be also considered for the purpose of holding the charge of the post pending a regular selection. In view of the said decision in such court in case of Muktaram so and so Jagannath Pegu, I am of the view that the not being eligible for in view of his invalid B.Ed degree for being considered for promotion to the post of headmaster of the school in question on regular basis, the petitioner could not have been allowed to hold the charge of the headmaster of the pending regular selection. The respondent number 4 being otherwise eligible in all aspects for being considered for promotion to the post of headmaster of the school in question. The petitioner who is otherwise ineligible could not have been preferred above the respondent number 4 in the matter of interim arrangement made for holding the charge of the post of headmaster of the school in question. So now, my lord, this there is a division bench order also, my lord, to that effect, that is Samir Majumdar in writ appeal number 124 of 2022. Lord, herein in every page, my lord, the Jagannath Pegos has been referred in, my lord. I straight away bring my lordship's kind attention, my lord, to start from paragraph 7 at page 6, my lord. Mr. So-and-so, the learned standing counsel for the secondary education department, Assam, has supported the arrangement of the appellant council and has further argued that earlier, in view of the provision contained in the rules of 2009, the respondent number 6, so my lord, this judgment has been relied and accordingly finding, my lord may be pleased to find. Sure. My lord may kindly find the para 14, page 9, my lord. This in the case of Jagannath Pegu, this court had made the following observations. So para 9 and 10 had been reiterated, my lord. Then, my lord, page paragraph 15. While endorsing the views expressed by the learned single judge in the case of the Jagannath Pegu, we further hold that while appointing the in-charge principal of the school, the authorities must, as far as practicable, adhere to the same principle as would be applicable while filling up the post of principal on regular basis. The learned departmental council has submitted that in view of the law laid down by this court in case of Jagannath Pegu, and pursuant to the publication of the rules of 2020, the department was duty bound to comply with the decision of this court and issue notification dated so and so in view of the fact that the writ appellant was senior to the private respondent writ petitioner, and he also fulfilled all requirement of the rules of 2020 for being appointed as a principal of the higher secondary school. After going through the materials available on record, we do not find any grounds to discard the above argument advanced by the learned departmental counsel. If that be so, the present is clearly not the case of the replacement of one ad hoc appointee by another, but it is a case where, pursuant to the change in the rules, the department has initiated the corrective measures so as to comply with the rules. In that view of the matter, the decision of the Supreme Court rendered in the case of so and so relied upon by Mr. Sikar, in our opinion, would not have any relevance in the facts and circumstances of the case. We are of the opinion that this is not a simple case of replacement of one ad hoc appointee by another, but it is a case where the government has initiated corrective measures so as to comply with the rule in force, as well as the earlier decision of this court rendered in the case of Jagannath Pegu. Since the appellant is senior to the respondent number 6 writ petitioner, and he fulfilled the requisite criteria laid down by the rules of 2020 for being appointed as a principal of the school, the authorities were duty bound to appoint the writ appellant as in-charge principal, even if it is a temporary appointment. The core question in these proceedings is not as to whether the writ petitioner respondent number 6 fulfilled the requirement of the rules of 2020 for being appointed as a principal, but as to whether the impugn order dated 30/6/2020 suffers from any infirmity warranting interference by this court. For the reasons stated herein above, the answer to the state question has to be in favor of the writ appellant. We are therefore of the view that the order dated does not suffer from any infirmity warranting interference by the court. Consequently, the writ appeal succeeds and the same is accordingly allowed. The impugned judgment order dated by the learned single judge stands set aside. Taking note of the submission of so and so is now proceeding. So, my lord, the law is well settled, my lord, that this is, it is a corrective measure, my lord. The manner in which, my lord, I have been conferred with the charge and with my, my lord, the writ petitioners are represented by my respected senior friends, my lord, do not have the very basic of the requisite qualification of B.Ed. So that one ad hoc replacement by one ad hoc, that concept is not applicable here, my lord. So that is my limited submission, my lord. So therefore, the order which by I have been given the charge may not be interfered with by this honorable court, my lord.
My lord.
Yes.
My lord. My learned friend, my lord, submitted and referred the cases where first appointment of in-charge headmaster, my lord, while the post was vacant. But in my case, my lord, in my case, I have been appointed, my lord, as in-charge headmaster in the year of 2018. And that time, my lord, petitioner has not raised any objection, my lord. After 4 years, in 2022, my lord, he came before this honorable court, my lord, and raised the objection while he obtained a B.Ed degree in the year of 2021, my lord. My lord, kindly see the Supreme Court order I relied, Manish Gupta versus another, my lord. It is while a temporary arrangement has been made already, then, my lord, no other temporary arrangement has been replaced, my lord. My lord, kindly see, it is a case where, my lord, there is a scheme, my lord, introduced, my lord, kindly, may I read from the beginning, my lord?
present appeal challenge the common judgment and the order dated so and so passed by the division bench of the High Court of Madhya Pradesh, Gwalior bench in writ appeal number so and so, along with the companion matters, thereby allow the appeal filed by the state of Madhya Pradesh as well.
Atia, yesterday you have referred this judgment. It is available on the record
My lord,
on his Gupta's case.
my lord, kindly see, it is, my case is that I am holding the post of in charge headmaster, my lord, since 2018, my lord. Now, my lord, at
No,
this moment,
No, Mr. Atia,
my lord,
as per rule,
as per,
you have no qualification to.
yes, for the regular appointment of the headmaster, I have no objection if he appointed as regular headmaster, my lord.
Hmm.
I have no objection if the authority selected him as regular headmaster, my lord.
Hmm.
But as ad hoc, he cannot be replaced, my lord. Is a clear case, my lord. There is another case, my lord. I referred, my lord, is Harguru Pratap Singh versus State of Punjab, my lord. Kindly see the case, my lord. Here, my lord. Kindly see the paragraph 3, my lord. We have carefully looked into the judgment of the High Court and other pleading that have been put forth before the court. It is clear that though the appellants may not be entitled to regular appointment, as such, it cannot be said that they will not be entitled to the minimum of the pay scale, nor that they should not be continued till regular incumbent are appointed. The course adopted, the High Court is to displace one ad hoc arrangement by another ad hoc arrangement, which is not at all appropriate for those persons who have gained experience, which will be more beneficial and useful to the college concerned, rather than to appoint person fresh on ad hoc basis. I have no dispute, my lord, that he is the qualified person. On the at the relevant state, my lord, he was the senior, but he has not the so qualified, my lord. He, while he denied to hold the post, my lord, the authority offered me the in charge headmaster post, my lord. I am continuing in the post, my lord. Suddenly, he came and claimed the post. And not for regular, my lord, for ad hoc or temporary arrangement, my lord. One temporary cannot be replaced by another temporary arrangement. And in the basis of this Harguru Pratap Singh, my lord's case, the recent Manish Gupta's case has been decided, my lord. In the and my lord, Meena Goswami's case is elaborately discussed.
No, this observation by Supreme Court is in different context. This decision, may not.
They appointed some person on temporary basis. They appointed some person on temporary basis for 1 year. And after 1 year, they again,
No, here in the present case, the question is quite different. Here
my lord, it will be clear on Manish Gupta's case, my lord.
headmaster.
Temporary post, my lord. Temporary arrangement, my lord. Kindly see the Meena Gupta's case, my lord. It is elaborately discussed, my lord.
Jagannath Pegu's case is prior to Meena Goswami's case.
Yes, my lord. Yes, my lord. Jagannath Pegu's case for the fresh post, my lord. There was no in charge headmaster, my lord, at that time, my lord. Or, my lord, it is the fresh, my lord, an instant objection, my lord.
Okay.
But I have been continuing in the post, my lord, since 2018, my lord.
Okay, we'll pass the order.
Obliged, file.
Second verification.
Lord, in this case, my lord, we have filed an interlocutory application, my lord, seeking withdrawal. I have to get. Yes, my lord. I have an instruction, my lord, that there is a bunch of petitioners, my lord. So that's why I have filed an interlocutory application stating the reason that why they want to withdraw, my lord. Lord, can the liberty, my lord, dispose of it?
IA is for withdrawal.
Withdrawal, my lord. Our IA, the applicant.
You have
Petition from.
in fact, in this matter lawsuit, I have also filed an IA
For?
only for a reason, to exempt from the cost. There was your lordship has directed the department to deposit a cost of.
No, you deposit the cost.
Lordship, in fact, we have already filed the affidavit. We have filed affidavit and.
No, after imposing of the cost, my lord, affidavit has been come as well as the IA has also been
No,
come.
no.
Our
We'll
IA.
again impose cost upon.
Well,
Only on the, I will leave it to your lordship, but only on the genuine ground, lordship. I have already.
Genuine ground.
Genuine ground is lordship, although the matter was listed in 2020, it was in the series matter. And in the series matter, lordship, in some of the cases might have been filed affidavit, but subsequently this matter has been segregated from the series. And ultimately it was listed, lordship, may kindly, there is one paragraph and then I will leave it to your lordship, because there is a genuine ground.
No,
And
that IA is not before this court.
this IA is there, lordship. IA.
withdrawal IA to 9. For record 9. আমার IA নাম্বারটা কেমন কেটে ফাইল করেছে
Your IA is not before this court now.
সেইটো কোন ডিপার্টমেন্টের তো না আমার আপনার তো তখন তাহলে চেক করা না
Mr. Here, Bhuya, learned counsel for the applicant, Mr. P.N. Sharma, learned something counsel for the respondent. Secondary, elementary education department. Lord. This interlocutory application under section 151 of the Code of Civil Procedure is prepared by the applicant for recording permission to withdraw the connected rate petition being WPC number 164/22. Mr. Bhuya learned counsel for the applicant submits that he has the instruction to withdraw this petition. Mr. Sharma, any objection? No.
No objection.
Sharma submits that he has no objection in the event of according permission to the applicant to withdraw the petition number. Accordingly, taking note of the submission of current counsel for both the parties, this court is inclined to allow this application. According permission to the applicant to withdraw the petition number. In terms of this IA is closed.
Lord, only that liberty may be given, my lord, if
The
required.
liberty will remain with the applicant to approach this court again by filing appropriate petition.
My lord. Highly obliged.
In this matter, my lord, senior counsel came to do will appear, my lord. Can it be taken at 2, my lord?
Lordship,
He's on legs, my lord.
probably today I have some difficulty, Lordship. I'm not well, Lordship. I'm having fever, Lordship. Lordship, can it be in the next week, Lordship?
But several
Today,
days have
Lord-
passed, my lord.
Lordship, on the last occasion, Lordship, it was. I didn't opt for adjournment, Lordship, on the last 2 occasions. Lordship.
Heard Mr. S. thus learned for the petitioner that Mr. Upamanyu learned dissenting counsel for the higher education department. Mr. Upamanyu submits that he has some difficulties to argue the matter today. As he is not feeling well, and he pressed for listing the matter after a week. We are allowed to list the matter on 25th November.
Can it be taken as the top of the list?
It will come 24th matter.
20.
What urgency is there?
My lord, they are, my lord, we're not, at any time, my lord, their contract may be terminated, my lord. All the contractual teachers, my lord. So some urgent contractual.
But their Lordship seeking.
Tenure will end when
Anytime, because they are contractual, my lord. So, my lord, anytime, my lord.
for a definite period.
No, they have been extended, my lord, time to time. They are
When the next extension will expire.
March or
March.
June, July, something like that,
Today we are. Okay.
my lord.
Okay, at 2 p.m.
My lord.
Lordship, not today, Lordship. On 25th, Lordship. 25th. Oh,
My
sorry,
lord.
sorry.
Highly obliged.
Highly obliged.
Yes, Mr. Sarma. That IA. Is yet to be listed. Okay, we'll see.